Okay, so we're going to get started. So first of all, welcome everybody. We have absolutely huge numbers tonight. I'm very excited about that and very grateful for everybody taking the time in what I'm sure are very packed Zoom schedules to attend this Zoom with us this evening. This event is hosted by the Jack and May Nathanson Center on Transnational Human Rights, Crime and Security at Osgoode Hall Law School at York University. My name is Heidi Matthews. I'm an assistant professor at Osgoode, where I also co-direct the center, along with my colleague, Francois Tanguay-Renaud. I'll be co-moderating this event tonight with Malavika Kasturi, who is an associate professor in the Department of History at the University of Toronto, and who also holds a graduate appointment in the Department for the Study of Religion. We're delighted again for the turnout. It's an incredibly important topic and event, and this is really, I think, going to be an exciting evening. So the Nathanson Center works to facilitate a cross-disciplinary program of research and project initiatives that enhance knowledge of issues related to a variety of transnational phenomena that are rapidly changing and challenging society, law, and governance. This evening's event is the first in a teach-in series that's titled Equity and the Azarova Affair. Our topic for today is aptly titled, What the Hell Happened at the University of Toronto Law School, and addresses the events that led to the recent censure of U of T by the Canadian Association of University Teachers. The center believes in fostering full, open, and frank discussion around the difficult but pressing issues of academic freedom, donor influence, and obstruction of speech around Palestinian and other marginalized people's human rights. This series is conceptualized and organized by Malavika, all of today's panelists, Melanie Newton and Emily Albert. I want to thank them for all the hard work that's gone into making this event a reality, as well as Liel Gonzalez, who is the Nathanson Center's coordinator. When we gather together in person at Osgoode for events like this one, it's our practice to begin by acknowledging the land where the law school is located and the many Indigenous nations that have lived there and caretaken it and who continue to do so today. We reflect on the connections, the fellowship, and the responsibilities that come with studying law and teaching in a territory where complex systems of governance, morality, and pedagogy have long been practiced and are indeed inextricably tied to the land itself. Osgoode is located in the area known as Takaranto, and I want to acknowledge that this is the traditional territory of many Indigenous nations, including the Anishinaabeg Nation, the Haudenosaunee Confederacy, the Huron-Wendat, the Métis, and the current treaty holders, the Mississaugas of the Credit First Nation. The land is now home to many Indigenous peoples and is subject of the Dish with One Spoon Wampum Belt Covenant. I'd also like to acknowledge the land on which I find myself today, which is situated in the traditional territories of diverse Indigenous groups, including the Beothuk, Mi'kmaq, Innu, Inuit of the province of Newfoundland and Labrador. So the structure for this evening will be as follows. Emily Albert will say a few words about how students, both in Canada but also globally, can get involved in concrete action around the censure. They will be followed by Malavika, who will briefly describe the goals of the teach-in series and introduce each of our panelists. Each of the panelists then will speak for 10 to 15 minutes, give or take, after which we will open the floor to a question and answer period. And so if you want to ask a question, you can do so by entering it in the chat window. And please include your name and affiliation when you do so. I do want to emphasize that this is a respectful and collegial space. And so while we welcome a variety of interventions, we do ask that you remain respectful at all times. We won't likely get to all your questions given the numbers this evening, but we'll do our best, of course, to engage as deeply and widely as possible. And I should also note that this event is being recorded and also live streamed on the Nathanson Center YouTube channel. And you can, of course, feel free to live tweet the event using the hashtag U of T censure. And if you want to keep up to date on the censure, please follow at Censure U Toronto on Twitter. So thanks once again, everyone, for taking the time to join us. We're delighted to be able to foster this important conversation among such a large and varied audience. And so with that, I will turn the floor over to Emily.
Hi, thanks, Heidi. I don't want to take up very much time at all, but just to say that if you are a student here and you do want to get involved in organizing around either the censure or the issues that underpin it that we're going to talk about today, please just feel free to send me a message directly in the chat. It's Emily Albert, and we can connect.
Good evening, everyone, and thank you for taking your time out of extremely Zoom busy days, as Heidi said. And I want to thank every single member of this panel, this really marvelous panel, in helping what we hope is the first of many teach-ins on an extremely important subject. So as we are hopefully speaking to a very broad and diverse audience, I'd just like to start by actually framing the event by actually very quickly talking about what who the Canadian Association of University Teachers are and what the census is. And in many ways, why we should, as those who are interested in universities and the idea of academic freedom and a variety of narratives that are which are very layered and very complex, why we should be interested as students, as parents who are hoping to send children to university, as faculty, and as those who are broadly interested in public education. So on April 22nd, 2021, the Canadian Association of University Teachers, known as CAUT, imposed a censure on the University of Toronto over its decision to terminate the candidacy of Dr. Valentina Azarova, who had been chosen in 2020 after an exceptionally rigorous search for the directorship of the International Human Rights Program, IHRP, at the Faculty of Law. The Human Rights Program was also exceptionally well known for its partnership with Amnesty International, amongst other institutions, which have since removed themselves from any association with the program. Now, Dr. Valentina Azarova is a human rights lawyer, and she was the unanimous and enthusiastic choice of the selection committee. And until, as CAUT notes, and I quote directly, but the negotiations to finalize an offer to her were abruptly cut off after communications from a wealthy alumnus, donor, and sitting judge. And particularly, quote, end quote, and particularly in the light of her research, which and her work as a human rights lawyer, which included the study of Israeli conduct in the occupied Palestinian territories. Now, while our first speaker, Denise, is going to go into this issue in greater detail, the reason for the censure in 2021 was about the fact that an eligible candidate who was head and shoulders above the rest, who was eminently suitable, was abruptly terminated after being selected by the selection committee. And the term censure, for those who are not familiar with it, actually is the equivalent of a boycott. It means it asks members of universities who are members of CAUT not to accept appointments at the censored institution, in this case, the University of Toronto, not to accept not to participate in academic conferences there, not to accept any distinctions or honors that might be offered in that institution, which includes honorary doctorates, for example, unless Dr. Azarova was reinstated. Of great concern for COUT was the breach of what they call the breach in the basic principle of academic freedom, amongst a whole host of other important issues. So, which is not just a Pandora's box, but actually, in a sense, lays open a whole series of vitally important issues for us as teachers, as students, again, as those who are interested in public education, and more broadly in the idea of what academic freedom is. So this is the first of many, hopefully, a series of teach-ins, and we welcome feedback after this first event is done, which will examine, illuminate, and discuss the issue at the law school, but then also seek to ask the question why it's an issue that it's important for the law school and why it's important for everyone else, right? Everyone else who is connected in different ways. So, this is a very pertinent time to be talking about the issue of academic freedom, especially when it is in threat around the world, right? Not only in liberal democracies, but also more broadly also in populist spaces, something that our speakers will be also addressing. But more than that, these teach-ins will point our attention to the ways in which academic institutions, in fact, construe and construct the idea of what is academic freedom, what can be taught, what cannot be taught, and in what context, for example, Palestine can be taught, right? And in this case, what is silence? So in many ways, the university, which we, and by that, which is why I say not just University of Toronto, but all universities whom we think and we assume are bastions of, sort of freedom of speech, are actually part of the problem, right? And are also as much silencing certain narratives. So which is what we hope that all the teach-ins will, this is the first, and without further ado, I'm going to, once we close, I'm going to be telling you a little bit about the teach-ins in the future, but without further ado, I'd like us to basically, I'm going to cede space to the main speakers of today, and I'd like to invite Denise Room to come and speak. Denise Room is Professor of Law at the University of Toronto. Her main areas of research are discrimination and equality rights under the Canadian Charter of Rights and Freedoms. She has taught courses in torts, gender and the law, multiculturalism, race and the law, and language rights. She is also a founding member of the Women's Court of Canada, dedicated to showing the Supreme Court how to apply the Charter equality provision properly. Denise, I hand the floor to you.
Thank you, Malavika. So, what the hell happened at the Faculty of Law at the University of Toronto? Last September seems like a long time ago, and there's been a lot of water under the bridge. If we could have done something like this last October, it would be very different from what we have to do now. There is a lot of detail that one could go through. A lot of events have happened, a lot of conversations have happened, a lot of letter writing campaigns have happened, and no 15-minute block of time is sufficient to cover all of that territory. So what I want to do is first take you back to early last September to kind of put you in the moment at which the decision was taken not to terminate the hiring process in respect of the director of the International Human Rights Program, but then to having zoomed in on that very narrow slice of time, to then zoom out and look at what has happened within the university in the months since then. Because that's really what helps us to see the significance of that, that small event. It might seem after this much passage of time like a small event, but it helps you see the significance of that small event in respect of some pretty important issues. So I want to take you back to last September by inviting yourself to put yourself in the shoes of the faculty member who is both the chair of the advisory committee for the IHRP and the chair of the selection committee for the new director. You spent the whole summer on an international search for a candidate. You've gone through 146 applications. You've winnowed it down to 3. Of those 3, 2 of them would require a work permit in order to be able to take up the post. Only one of the 3 would be automatically entitled to work in Canada. There's a clear first choice, and that person is somebody who needs a work permit. That's Valentina Azarova. The process has begun to start working up the paperwork to get that work permit underway. Everything seems to be ticking along just fine. All the signs from all conversations are that things are moving forward. Now, on the Friday before the Labor Day weekend, all of a sudden you get wind of the fact that an alumnus who's well connected to the Faculty of Law has raised an objection to Valentina Azarova, and the objection has to do with some of her scholarship on the possibility that Israel has committed human rights abuses in respect of Palestinians in the occupied territories. And then over the holiday weekend, in the space of 2 days, a decision is taken to terminate the hiring process. So if you were that person on September 6th, you would know a little more than that. You've had one conversation with the dean who has offered a couple of reasons for not wanting to proceed with the appointment. You find those reasons quite weak. And the dean denies that this so-called donor intervention has anything to do with anything. But the process is terminated. So there you are back in the moment. And I invite you to ask yourself, what would you think at that moment in time? Would you think, hey, wait a minute, something doesn't seem right here? Or would you shrug your shoulders and think, well, the dean must know best. I'll just get back to the rest of my work. It's important to ask yourself that question because it sets the stage for everything else that happens. Now, of course, if the decision to terminate this hiring process was in any way because of the objection that was raised by David Spiro, who is the alumnus, this is a serious violation of the university's core principles, including academic freedom. Now, the university, and ultimately Thomas Cromwell, whom it commissioned to produce a report about these events, interpreted the issue quite narrowly as a matter of whether the dean understood himself to be caving into external pressure. And throughout this entire process since last September, the persistent focus has been, in effect, what was going on in Dean Ed Iacobucci's head, and was it good or was it bad? That's the way the issue has been framed. Now, I have a problem with that interpretation of the issue, because as in many other contexts in which we're trying to figure out why somebody did something, it makes it too easy to obscure reasoning that we actually want to shine some light on, to just say, well, the question is, what did that person think that they were doing? It's too easy to obscure what's really going on if the issue is defined that narrowly. In the discrimination law context, for example, it is received wisdom that no savvy employer ever admits that race or sex or some other prohibited ground of discrimination was a factor in a decision that was made. And I think we can assume no university administrator is ever going to admit that he was influenced by external pressure from a donor. But I'll take one step further. Just as an employer can base a decision on race or sex or some other prohibited ground, even if he doesn't see himself as doing that, even if that's not his self-understanding, it can still be true. So a university administrator can be influenced by external pressure, even if he doesn't see it that way himself, even if that's not the way he understands his own behavior. We all want to think of ourselves as good people. And so we present our actions in the world to ourselves as well as to others as based on acceptable, not inappropriate reasons. That's human nature. So if you focus the question very narrowly, as the university did, on whether the dean understood himself to be caving into external pressure, you prejudice the outcome, and you don't get at a lot of what's important around the issue. So I think it's a mistake to understand the issue as narrowly as that. But now I want to zoom out from the events of last Labor Day weekend and trace a little bit, as quickly as I can, the university's response to the fact that faculty, IHRP partners, alumni who had been participants in the IHRP, student groups, raised a hue and cry over the termination of the Azarova appointment. Now, there's a sense in which I can be brief here, because despite strenuous and repeat efforts to ask questions, to get the university to talk to us, to engage with the questions, etc., the response from the university was largely silence. So various members of the advisory committee of the IHRP reached out to the dean and said, hey, we got a problem here. We'd like to understand what's going on and talk to you about whether this is the right decision to make. The dean would not even acknowledge their emails and phone calls. By September 17th, the dean finally did make some kind of public statement to the law school community. And that statement consisted of a dollop of outrage that anybody could possibly think that he could have done anything wrong like this, a certain amount of hiding behind the collegiality of the process, and some vague references to the program's timing needs that the preferred candidate could not meet. And that was as much explanation as the law school community got. I'll just say in passing that it always seems to me that when you suggest to somebody that they might have done something wrong, and their first response is to be outraged that you could possibly think they've done something wrong, that should make you more, not less, suspicious. But in any event, getting nowhere with trying to persuade the dean that there needed to be a conversation about this, that maybe this wasn't the right decision. And I emphasize that all of this was done entirely within the faculty, behind closed doors, no publicity, no going to the newspapers or any of the rest of it. But getting nowhere within the faculty, some of us started to approach the provost, who's the most senior academic official in the university, and in some sense, the boss of the dean, in order to see if we could get the provost to engage. Again, the answer was silence, nothing. We heard nothing back from senior administrators. We argued that there needed to be some kind of investigation into what had gone on here because it certainly didn't look good. The IHRP's reputation was at stake. The university's reputation was at stake. Those of us in the law school and the faculty not only made the point to the provost that that academic freedom principles were at stake, but also that collegial governance was a background issue, that the behavior of the dean just amounted to a complete breakdown of collegial governance. But as I say, silence. On October 14th, we get an announcement. So this is now 6 weeks in. We get an announcement that there will be an investigation of some sort. This is after weeks of being told there was no need for an investigation. There will be an investigation of some sorts. But it comes out as an edict from on high, no consultation with people who are engaged in the issue, no consultation with anybody, the university just deciding for reasons best known to itself. The basic process that it suggested at that time was highly problematic. And so we went back to our keyboards again and wrote more letters. This time going over the provost's head to the president. Now, a couple weeks later, we get another announcement from the president's office, and the indication from the announcements is that some of the criticism has been heard because the process that it was initially suggested has now been tweaked. It's been improved in various ways, not nearly enough, but it's been improved in various ways. But again, no consultation, just an edict from on high. So we write letters to President Gertler and say, still not good enough. And he announces on October 29th, so, again, minor changes. But we did actually get a response from President Gertler. So I'm looking at my email inbox and thinking, oh, this is progress. Here's a reply from President Gertler. But it was a little bit disappointing. Patronizing is the best way that I could describe it. Don't worry, I understand your concerns, but don't worry, it'll all work out. We've done the best job. We've done what we think is a perfectly fine job here. And interestingly, in retrospect, he said in passing that he looked forward to full consideration of the report when it was handed in. We're still waiting, I should add, for that full consideration of the report. December 7th, we get more tweaking of the process. But again, this is all edicts from on high, no consultation with anybody. The first person who was put in place to do the review is ousted in favor of Thomas Cromwell. There's a few little improvements to the process, but it's still not nearly as good as it could have been, should have been, would have been if there'd been any consultation. And then there's a bit of a lull. The Cromwell report is itself submitted to the university on March 15th. It is released to the public on March 29th. Again, a group of colleagues from the Faculty of Law send a letter to President Gertler, outlining briefly what we thought were the main problems with the Cromwell report, which is inadequate in many, many ways. The response, which turned out to then be the response given to the university as a whole, was he's a respected jurist and he is independent and he heard all of the evidence and we should just listen to him. We should just believe him. We should just go along with his conclusions because he's a respected jurist. Now, since then, there's been a flood of criticism directed at the Cromwell report, and that is what has culminated in the CAUT censure. Throughout all of this, the university's response has stayed the same. He's a respected jurist who's independent and we should just believe him. He's seen all of the evidence. In fact, there is nothing in the Cromwell report that we sort of didn't already know, except various things that make the university look very, very bad, worse than any of us thought. But the university wanted to focus on this narrow issue. Was Dean Iacobucci influenced by the donor, David Spiro? And since Cromwell said, no, I don't think he was, the university said, that's the end of the question. In respect of a few other issues, the university's basic response was, yeah, well, mistakes were made, but, and Cromwell offered some advice about how we could do some things better. But don't worry, folks, we'll fix it. We, the university administration, will fix it. Now notice the overall picture here, because this is what's important. The university is being run, has been being run through this entire process like a large private corporation. What the boss says goes. No one needs to be consulted. No accounting of oneself to one's peers is necessary. The only people you need to account for yourself to are people who are higher up in the food chain. That hierarchical approach to governance within the university has, throughout this whole process, fostered a perception that the decision not to hire Dr. Azarova was a violation of academic freedom. Worse than that, that approach to governance means that it will almost always be a fluke when we discover that external lobbyists try to, or indeed succeed, in meddling in an academic decision. It was in fact an accident in this case that anyone was alerted to Spiro's meddling. The assistant dean happened to tell the chair of the search committee that there had been this effort to interfere. The university spent months resisting all requests to conduct any kind of investigation. Now it says that it will fix it. Now, even if we have no reason to believe that this won't happen again. We should worry that steps will be taken to make sure that it doesn't ever come to light, that nobody ever finds out when it happens. And so it would be a dereliction of our duty as members of the university to let the university dictate the extent to which academic freedom is protected. Only collegial governance can provide the kind of protection for academic freedom that is necessary. So what the hell happened at the Faculty of Law at the University of Toronto? Here's the bottom line. An organization that did not want an advocate for Palestinian human rights to be hired got a friend to have a quiet word. That quiet word reached the ear of the dean. The advocate for Palestinian human rights was not hired. The university has spent 9 months not hiring that person, professing all the while that it believes her to be the best qualified candidate and that it is committed to merit-based hiring without discrimination because of political views. So what happened at the Faculty of Law at the University of Toronto? You decide.
Thank you, Denise. So that was, there are many, many points here that we can come back to and return in the Q&A. But now I'd like to ask Mohammed Fadel to speak on the question of Palestinian exceptionalism. Mohammed is a full professor at the Faculty of Law, which he joined in January 2006. He wrote his PhD dissertation on legal processes in medieval Islamic law while at the University of Chicago and received his JD from the University of Virginia School of Law. He was admitted to the Bar of New York in 2000 and practiced law in New York, where he worked on a wide variety of corporate finance transactions and security-related regulatory investigations. Professor Fadel also served as a law clerk to the Honorable Paul V. Niemeyer of the United States Court of Appeals for the Fourth Circuit and also at the United States District Court for the Southern District of Georgia. Professor Fadl has published numerous articles in Islamic legal history in Islam and liberalism, and he is now going to be talking to us about an extremely important and related subject and continue the conversation which Denise has started with such great work. So, Mohammed, please.
Thank you, Malavika. I'd like to start, first of all, by thanking the incredible support that we've received from colleagues across the university, across Canada, and across the world. I got involved with this maybe a week after the critical weekend. Just to give you some background, I'm not involved in the IHRP program. I'm not snooping around about the IHRP program. I didn't look for scandal. The scandal came to me, right? When another colleague, Ariel Katz, who's also worked very energetically on this, emailed me and said, have you heard anything about this? Because I got a message from a colleague in Israel about this. And the whole thing I found to be incredibly shocking. And I found a hard time actually believing it. So maybe as an aggressive American, I was told later on, I actually wrote a formal letter to the former dean, not even an email, saying that this is what I've heard is really bad. And if it comes out, it's going to be catastrophic for the law school and for you. So please reconsider. And then, of course, if this is all erroneous, please let me know. So that's how I got involved in it. It's not something I went out to look for. But once it came to my attention, I believed it was my obligation to get to the bottom of it, right? And I think that's a fundamental part of the ethos of being a lawyer. And one of the things that you mentioned in my biography is I was a securities lawyer. I worked on Wall Street. I represented some big banks that people like to hate. And I was just laughing when Denise said that the University of Toronto throughout this process has acted as a private corporation. I would amend that by saying a corrupt private corporation. Because I actually did represent clients that were accused of substantial wrongdoing. And let me tell you, we investigated the hell out of them. And I know what a real investigation looks like. And nothing like a real investigation happened here, right? The Cromwell report is nothing close to a real investigation. But that's not my mandate to get into why it was a whitewash. But anyway, I just wanted to get that out there. Now, I was charged with talking about the Palestine exception. I mean, I guess one could go back to theology and get into some sort of stories about favoredness and disfavoredness, et cetera, et cetera. And all of that, I think, is very relevant in the background, because when we talk about Palestinian exceptionalism, we're talking about a regime in which rights that are normally associated with everybody, Palestinians are excluded from. So that's the negative side of Palestinian exceptionalism. The things that we take for granted that we're entitled to, like freedom of speech, freedom to tell your own story, et cetera, that is denied to Palestinians. But there's a flip side to that. You can call it the positive sort of Israeli exceptionalism. And in campuses, the positive Israeli exceptionalism or Zionist exceptionalism is the right to be able to tell your story without it ever being challenged. So alone of any kind of religion, philosophy, ideology, governing system, you are not allowed to question Zionism. Questioning Zionism in and of itself is anti-Semitic, we are told, right? So you can actually question democracy on a university in a democracy and challenge the validity of democracy, challenge democracy as a worthy way of life, advocate for some kind of hierarchical philosophical state headed by a philosopher king, and that will be recognized as part of your academic freedom. But there will be serious people, maybe not serious academics, but there will be serious people in society who challenge your right to question the legitimacy of Zionism as a political movement. So that's the positive side of Palestinian exceptionalism, called sort of Zionist exceptionalism. Now, this Zionist exceptionalism isn't tremendously powerful because, for very good reasons that we all know, right, anti-Semitism has been a horrific scourge. And we should not forget that Canada was one of the most anti-Semitic countries in the English-speaking world, right? Despite the Holocaust, Canada refused to accept any Jewish refugees from Europe. I think the slogan was, none is too many. So it's hard to exaggerate the kind of moral debt that Canada owes out of this history of anti-Semitism, right? But creating an exceptionalism for Zionism, making it immune from political critique, is not a way of paying that debt, right? Because that debt is being paid in the lives of Palestinians, right? And so if you go back and look at the details of the facts as set out in the Cromwell report, what's stunning is the kind of uncritical or assumed privilege that the anti-Azarova coalition displayed. So Justice Cromwell tells us that, I'm going to use the word plot because I think that's the way to describe it, there was a plot hatched to prevent the University of Toronto from hiring Dr. Azarova. This plot seemed to have originated somewhere in the faculty of the University of Toronto. We don't know where, it's unidentified. Some member of the faculty, which we presume is somewhere in the University of Toronto, contacted some professor outside of Canada. This professor outside of Canada then apparently does some research on Dr. Azarova and prepares a memo on her. Then sends this memo to CEJA in Canada. And then CEJA reaches out to Justice Spiro and just openly asks Justice Spiro intervene and get the university not to hire her, right? Not because she's a bad lawyer, not because she's an incompetent scholar, right? Not because she's committed some crime of moral turpitude, but because she has the temerity to defend Palestinian human rights. It's shocking the amount of privilege that is evident in the actions of these people, right? There's no sense of any kind of wrongdoing in acting in this way. Now, Justice Spiro, being a judge, had enough good sense to realize he couldn't do this directly. He couldn't just do exactly what CEJA asked him to do, pick up the phone and ask the dean not to do it. But it's not as though he did the ethical thing and said, you know, guys, I don't like Azarova's views, but I can't really do it because to do so would be breaking the rules of the university, and I just can't do that. That's not what he said, right? He arranged to have a call with the assistant vice president for advancement. He brought up the issue with her. He told her, I can't talk to the dean because that would be wrong, right? But you should let him know, right? Now, the assistant vice president isn't an idiot. She's a lawyer, in fact. She's a very highly paid official of the university. She's not some clerk, right? She had experience working in advancement at the Faculty of Law. Now, she has completely internalized, apparently, the Palestine exception, either on the negative side or the positive side, because she doesn't express any surprise or objection. She doesn't say, Justice Spiro, you're asking me to violate a confidential hiring process. She just sort of says, you want me to jump? How high do you want me to jump? Right? So again, there's a kind of complete internalization of this idea that either Palestinians don't get the same rights as everybody else, or Zionist advocacy gets more rights than everybody else. The two go hand in hand, right? Now, again, I would say that this is despite the fact that she understood that there was something wrong with this. Again, you go back to the Cromwell report, she keeps a log of her calls with major donors. Her log did not mention anything about this conversation, right? So it seems to be that she wanted to do this all in ways that would not show up and leave a record, okay? So how is it that this official, this AVP, just knows to break protocol when Justice Bureau asks her to do so, right? Again, I would say it's because of this generalized view that Palestinians don't deserve the same kinds of respect and treatment and standing that everybody else gets, right? Again, is that either a negatively against Palestinians or positive discrimination in favor of Zionism? I can't really say because the two go hand in hand together, right? Now, this is not the only incident in which this has happened in North America. As far as I know, this is probably the first time it happened at a Canadian university. But there have been several major incidents of this sort in major US universities in the last 20 years, right? So I went back and did a little digging before in preparing for this presentation. In the mid part of the last decade, or the first decade of the year of this millennium, I forget, we're now in the third decade, Yale considered hiring Juan Cole from Michigan to go to some sort of, I think, joint appointment in history and sociology, despite the fact that both the departments of history and sociology wanted to make this offer to Professor Juan Cole. I don't remember exactly what official at Yale intervened, but they intervened and withdrew the offer. This intervention came after a big hue and cry from the media, from the right-wing media, opposing the appointment because Dr. Cole had become quite controversial. He maintained a blog called Informed Comment, in which he was highly critical of the Bush administration's war on terror and Israeli conduct toward the Palestinians, right? Now, Yale, of course, denied that Professor Cole's his work as a public intellectual had anything to do with it. But again, that's sort of like high profile case number one in the United States. Second, more or less around the same time, Columbia hired Rashid Khalidi, who was my former professor at University of Chicago, expert on modern Middle Eastern history, from a scion of an Arab Jerusalemite family. So his family has been in Jerusalem for hundreds of years. The most famous research library for Arabic manuscripts in Jerusalem is named after his family, right? Columbia hires him, huge controversy, right? And then a few years later, there's this massive scandal in which some students accused the Department of Middle East Studies of engaging in intimidation, anti-Semitism, et cetera, They're like filming people surreptitiously, et cetera. Big investigation happens, the department is exonerated, right? But again, the point is made that there is a very high price to be had for treating Zionism as any other kind of nationalist ideology. Because for a certain group of people, a certain powerful group of people, there's been a complete conflation of Zionism or anti-Zionism with anti-Semitism. Therefore, thereby successfully in most cases, earning immunity from any kind of academic critique. Right? The third case, which I'll just mention very briefly, and probably the most famous one is Stephen Salida. He was in American Studies, somewhat of Native American origin and Palestinian origin. He was a professor at Virginia Tech in American Studies. He was offered a job at University of Illinois with tenure as an associate professor. His hire happened around the same time as I believe, the 2008 Gaza War. In between the time in which he resigned his position at Virginia Tech and formally began his position at University of Illinois, all that was left was the Board of Regents sort of signing on the contract, which in all cases has always been a pro forma step. He tweeted angry tweets regarding Israel's conduct in Operation Cast Lead, which was normal because it was a horrifically violent war. So as a result of those tweets, again, we have a similar sort of situation in which a well-connected alumnus with who has given a lot of money to the university raises a hue and cry, and then the university backs down and withdraws the offer, terminates the offer, refuses to go forward with it, right? Even though this ended up resulting in a fairly large financial liability for the university. And this is the important thing, and this is one thing I mentioned to COUT, that it's important that they insist that an offer be restored to Dr. Azarova. Because for donors, from the university's perspective, and here I will sort of appeal to law and economics, the cost of breaching academic freedom, even if they lose in court, is less than what they get from these donors. So in the case of Salida, the university paid out maybe a little less than $1 million. But if you have a donor that's giving $50 million, you'll live with that as a cost of business, right? And so this is a serious structural problem where universities can just take adverse court judgments as a cost of doing business. Therefore, I stress to COUT that it's crucial that the censure only be removed by restoring the offer, because the university otherwise would be perfectly happy to pay a sum of damages to somebody whose academic freedom has been deprived, because most of the time people won't sue because of the headache, the difficulty, the emotional stress, and plus it makes you a black sheep in the academic community. So Stephen Salida, despite the fact that everybody recognizes how horribly he was mistreated, has not been able to get another teaching job, right? So the Palestine exception is real. It's destructive, right? It's destructive to the Palestinians and their supporters who suffer real, tangible, and intangible losses as a result. And it's also destructive to the academic integrity of the university because it acts as a device of censorship, prohibiting us from studying an incredibly important political movement of the 20th and 21st centuries with dramatic consequences for a very important region of the world because it hurts the feelings of a certain group. And in that respect, it's very similar to what we see in the United States with these movements to ban critical race theory. Because for certain Americans, for certain kinds of people vested in American exceptionalism, the idea that America is anything but pure innocence hurts their feelings so profoundly that it cannot be an object of study. And that's ultimately what's going on with Zionist exceptionalism in Canada and the United States. The claim is not that the facts are wrong. The claim is not that the Nakba isn't real. The claim is not that apartheid is not real. The claim is not that Israel is using horrific violence to punish Palestinians as opposed to actually exercising what lawyers, international lawyers would consider a right of self-defense. No, the claim is to talk about this is hurtful to us. And it should be shut down. And university administrators should not allow this to be discussed, right? So this Palestine exception is personally destructive and it's destructive to truth. And we all have a duty to stand up and resist it. Thank you.
Thank you, Mohammed, for bringing up this really, really important point, and drawing our attention to the occlusions and silences that are in fact growing as, shall we say, a large number of authoritarian states, sort of move in on different kinds of rights. Building on this and building on what you have said, and particularly its importance to the university per se, I would like to invite our next speaker, Vincent Wong, who's going to be speaking on the conservative backlash against anti-racist and decolonial education. So if I might just introduce Vince, he is a PhD candidate and a Nathanson Graduate Fellow at Osgood Hall Law School, where he researches racial capitalism and undocumented youth in Canada. He's also a research associate at the African American Policy Forum, where he co-leads the Truth Be Told campaign, tracking state-sanctioned suppression of anti-racist education, training, and history in the United States. Previously, Vincent was an adjunct professor and William C. Graham Research Associate at the International Human Rights Program at the U of T Faculty of Law. So, Vince, the floor is yours.
Wow, that was fire, eh? Like this is very intimidating. Coming off such an all-star panel, this is great. And thank you so much for the organizers, Nathanson Center and Heidi. Thanks to all of you. I was looking in the audience and I've just, a lot of great people I respect, scholars I respect. I've read a lot of your, like books and articles, so I'm really excited to talk to this audience. And where should I start? So the topic of this series is equity and the Azarova affair, yeah? And so what does this have to do with equity? And so I'm gonna try to frame this so that you can see, very tangibly how this is related to an all-out assault on equity, but specifically anti-racism, intersectionality, and decolonial studies. And so I'm going to try to share screen. Hopefully this works okay. Can everybody see that? Okay, there's some Google Slides there. All right. So I'm gonna talk about, okay, why is this related to the conservative backlash against anti-racist and decolonial education? And like Denise, I'm going to start, with the micro, right, and specifically my positionality in this whole kind of debacle, but then draw the conversation into much larger contexts and much larger sort of political and economic and social wins that this is situated in. So in addition, when we talk about this stuff, in terms of, principles, right? We talk about how this is a violation of academic freedom and collegial governance, which of course it is. And one of the things that we forget, however, is like the very institutional purpose of U of T with respect to human rights, right? So I just copied and pasted this institutional purpose of the University of Toronto, but in the Governing Council, October 15th, 1992. And, in the bottom, it says it is this human right to radical critical teaching and research with which the university has a duty above all to be concerned. And it talks a little bit about specific types of human rights, but this is right in the institutional purpose of the university, as I imagine it would be in many kind of mandate documents of universities nowadays, right? And I do this because I actually tried to argue this earlier on when I was still at the IHRP, when U of T was facilitating the recruitment of Hong Kong police unit leaders while they were attacking civilians, tear gassing, just egregiously violating the rights of protesters, that we were doing this, and the University of Toronto pretty much ignored us. So, here we are again with the Azarova affair. So I'm going to talk a little bit about my positionality. So I spent many years studying at the U of T. First, I was at Rotman Commerce, and then I did 3 years at the Faculty of Law, where I was, co-editor-in-chief of a magazine, a student-run magazine that the IHRP does called the Rights Review from 2012 to 2013. I came back in 2019 as a research associate. And so I worked there from June 2019 to September 2020 until my resignation over Dr. Azarova's termination. And then so, ironically, from September to December of 2019, I taught a clinical course as part of a large partnership called the Global Partnership to Protect Media Freedom. I bring this up because this was like kind of the only thing that me and Ed Yacobucci were on like the same thing for. It was like a media release, essentially that I drafted. And then I thought I would reproduce part of it. So we actually looked at like a whole semester of media freedom, whistleblowers, public interest, public accountability, and all of these sort of things, right? And I've underlined some of that, whistleblower targeting being a key issue, and that is increasingly under threat. And then there was like this quote from Ed, that this is great, right? Like this, legal scholars and lawyers are going to work on these contemporary issues. And then I just found that very, very ironic kind of later on when he's kind of thrown those values down the drain. I was also part of the 3-person search committee from June to July 2020, along with Alexis Archibald, the assistant dean, and Audrey Macklin, professor of law, to look for a director. And this was actually the second search committee that was formed. The first one came to a preferred choice for the director in around November 2019, also a non-Canadian. That person thought about it for a while, but ultimately didn't take the job. And I was pretty much brought on at the second crack at the can. And after given the news, shortly after the famous Labor Day weekend, that Dr. Azarova's candidacy was going to be terminated, Alexis, a lot of people don't know this, had emailed me notifying me of this, but also that the dean would be taking over the hiring process. I was like, word, we only have 3 people in this search committee. Only 2 of them have any expertise in human rights. That's Audrey and I. And the dean, who is like this law and economics specialist, has never done anything on human rights, is all of a sudden going to know, which of these people are going to be the best kind of human rights director. So that was just very interesting. And it kind of goes to what Mohammed was saying. It's kind of like the shocking privilege that you'd imagine that you would get away with this, and certainly because they had been getting away with this. Like, why would you act this way if you didn't think you were going to be challenged? And so going to once Cromwell came up with the report, right, which credit Cromwell, did a wonderful job on the facts. Like it unveiled a lot of the facts and kind of that Mohammed was talking about, Denise was talking about, in terms of how seedy this incredible affair was, this plot to by a Zionist lobby group to torpedo this hiring. I thought about, okay, well, why is it that this analysis is so wonky? So I did an intersectional critique of the Cromwell report, but also on initially, how this was handled, and published it in Opinio Juris. My major question was, what can an analysis about race, gender, and class tell us about how power and privilege are operating through our legal institutions? So the legal, certainly the law school, but also the judiciary, and also this power structure that was mediating this and coming up with such an incredible sort of outcome. And I argued that the intersectional analytic was helpful in revealing how racialized and gendered understandings of integrity, right, can be laundered to improper appeals to authority. So if anybody who's taken the LSAT, it's like, oh, this is an improper appeal to authority. But it's happening all the time with respect to the Cromwell report. Well, this is a famous former jurist, so you should just trust them, right? Like that's like the official line almost of the president. So this presumption of innocence that was so amplified and powerful when you're dealing with powerful white men at the apex of the legal profession, the most generous interpretations are applied to their conduct. Obvious meddling and, blatantly, this is borne out by the evidence, is only concern about due diligence. When Yakabuchi says, "Oh, I didn't do it," contrary to what everybody else has said, contrary to the fact that he didn't even know about this this hiring this candidate until he was informed by Spiro and canceled it over this 2-3 days. The fact that he says, "I didn't do it," of course he didn't do it, but it was so amazingly powerful coming out of this guy that it kind of suspended a lot of our thinking about evidence, about credibility, those sorts of things, and also idea about who gets thrown under the bus. It was pretty much women inside the administration that were said to the behavior fell below the standards, but the people who were the key players, Spiro and Yakabuchi, got to avoid any sort of accountability. And and the other thing Mohammed was really helpful in getting to was this idea of either a Zionist or a Palestinian sort of exception. Because one of the things that never got talked about was why isn't this a concern about national security, right? So you have this foreign sort of nationalist lobby who has torpedoed this person because they're critical of the human rights record of that state. Imagine if this was like a Chinese judge doing this, right, on behalf of some sort of Chinese lobby. We would have CSIS on here in a second, right? It would be just completely different. And that is kind of the exceptionalism of any sort of other right-wing kind of nationalist product that seems that Zionist exception has, right? So that's a little bit about the intersectional critique. But then I was thinking about it. I was like, oh, I'm trying to do this critique, but intersectionality itself is getting banned. So intersectionality, as many of you might know, is a key tenet of critical race theory. And critical race theory, there have essentially been roughly 30 bills introduced in state legislatures that will withdraw funding if there is a teaching of divisive concepts. This is like the whistleblow kind of term for critical race theory. And it's kind of being introduced as a part of an anti-CRT, anti-critical race theory disinformation campaign that restricts the ability for us to actually do anti-racist education or teach the history of great racial injustices in America. And if you can kind of see, this map that we built at AAPF, there are, this is kind of everywhere, including in states that are not necessarily considered red states. It's being introduced in places like Rhode Island and in New Hampshire as a way to silence, both in K-12 and in higher education, certain concepts related to anti-racist education, but specifically the ability to look at racism as anything else but individual prejudice, right? As anything that actually is systemically leading to maldistributions. So that was going on. And it's this kind of anti-CRT thing is actually migrating also to the Law Society of Ontario, right? So some people that are familiar with StopSop will know that that was sort of a statement of principles. And, the argument was that this was a violation of free speech. Some very good scholars like Joshua Seeley Harrington had said that this was free speech in form, but anti-equality in substance. Now, FullSop, the evolution of StopSop, has internalized this anti-CRT rhetoric and is now both, speech restrictive in form and anti-equality in substance, and has gone on to say that critical race theory is what is, the primary villain, and that we have to stop it by any means possible. So why do I talk about these two things that seem to be only like vaguely related? Well, there's two types of convergences that I wanted to talk about. One is the convergence in hardware. Well, I'll call it basically infrastructure of these two things. These are the actual parties that are advancing these kind of speech suppression campaigns. And then I'll talk about the convergences in software or the rhetorical strategy. So one of the big things that is happening now is that there is this critical race training in education map that is being used to lay the table for speech suppression. So for people to go after anything that is teaching critical race theory in either K to 12 or in higher education in the United States. And this is like sort of almost like the canary mission of critical race theory. So people can go after specific institutions, specific teachers, specific principals and superintendents that have a critical or systemic racism sort of pedagogy or bent. So if you can see that at the bottom left of this thing this is funded by a project of Legal Insurrection Foundation, which is one of the key legal arms of this anti-CRT movement. Well, the Legal Insurrection Foundation also started as a Zionist sort of lobby organization, which is founded by William Jacobson, a securities law professor at Cornell Law School. And they actually, as I was doing the research for the infrastructure behind the anti-CRT campaigns, it was coming up that, Legal Insurrection Foundation is also, really, really big and had this incredibly long kind of investigative campaign on the Azarova affair. And if you go to the website, this is an extremely long article, but it kind of like names names and attacks me in really strange ways though. So if you see on the right side, it will say stuff like, intersectionality is an ideology that is deeply hostile to Israel, and try to tie me to critical race theory, which is obviously true because I learned under these people. And like, oh my gosh, it's paying homage to leftist anti-Israeli icons like Angela Davis and whatever. So this was actually kind of the people were converging and melding, which I thought was really, really interesting. But I wanted to talk a little bit more, and this will be the last slide. I talked your heads off, I'm sorry, but more about rhetorically how this strategy is working, because you can't just come out and say, right, that I oppose decolonial studies, that I oppose anti-racist pedagogy, right, that I oppose equity. You have to take a certain sort of rhetorical steps in order for you to then suppress that speech, right? So I found kind of 5 sort of steps that people try to do in order to get to the point where you can shut this down, right? So one is to vilify and demonize anti-oppressive pedagogy. So for example, the idea that critical race theory is divisive or anti-American, or that drawing attention to the oppression of Palestinians is anti-Israel or like terrorist adjacent, so to make it like a moral panic. Number 2 is to obscure, right, we're talking about the systemic here, right? To obscure power imbalances by framing issues as complicated or controversial. So this is really, really helpful for the liberal crowd who won't want to talk about that politics, but want to just avoid controversy, right? So the idea that teaching about systemic racism or discrimination, colonialism, slavery, racial subordination is divisive, right? It teaches us to hate each other, and it makes people like ultimately feel uncomfortable, right? The third thing is to frame anti-racism as racism against dominant groups. So you see that in talking about systemic racism, privilege and power in the context of, let's say, Canada or the US is actually racism against whites. So this is reverse racism, right? Or that in the microclimate of Israel-Palestine, framing this as any kind of critical analysis of racial subordination or colonialism is itself actually anti-Semitism. That's what's racist, right? And then I think Muhammad talked a little bit about this, but essentializing, kind of centering the discomfort, right? That any idea that any challenge to American exceptionalism or any challenge to the Zionist exceptionalism is going to make certain people feel uncomfortable, and that's the reason why we are going to curb kind of research and education and the ability to talk about it. And finally, the use of withdrawal and funding and doxing and harassment. So this is kind of the culture of university donor influence, the erosion of collegial governance, certain kind of lists that will allow people to be doxed and harassed and subject to reprisal. That's kind of the mechanism. And if you see on these anti-CRT bills, about 6 or 7 have already been passed. maybe another 15, 16 are in the hamper. The main enforcement mechanism is the withdrawal of funding from education, both K-12 public education and higher ed. So this is the legal framework that allows, that formalizes this mechanism to suppress anti-racist education and decolonial education. So yeah, that's all I have. And yeah, really thank you for having me, and I will pass it over to Amber next.
Yeah, so thank you, Vince. That was great, and it actually speaks perfectly to the larger issues that I alluded to at the beginning, which demystify the university, not just University of Toronto, in fact, but all universities which cross the public and private divide as corporations, and the way they in fact constitute and in fact, sort of reinscribe silences in these complex ways that you've alluded to. So to come not quite full circle, but to add another layer to this issue, I invite Anwar Rehman to speak on the really important and a question of donors, philanthropy, and its impact on academic speech. And there's been a thread running right through what all these speakers so far have said. But let me briefly introduce Anwar, who actually who is a professor of law and history and a Canada Research Chair in Islamic Legal History at the University of Toronto's Faculty of Law and the Department of History, and directs the Institute of Islamic Studies at the University of Toronto. So Anwar, please, I hand the floor to you.
Thank you. I'm also mindful of time. We've kept all these folks, they've obviously been riveted in their attention with all of us, but I also want to be short, just to allow for some time for questions or comments. So I'm going to shorten my remarks, but I want to begin first, of course, by thanking the Nathanson Center, Malavika, and the whole team that are hosting us. I also want to thank my colleagues at the law faculty who have been brothers and sisters in arms. We talk about the failures of collegial governance, but in an ironic twist, this experience has been one of the most collegially refreshing experiences I've had, working with people like Denise, Mohammed, Ariel, David Schneiderman, who's now in Sweden and joining in at a rather ungodly hour over there. It's been really tremendous. And of course, the folks at Censure U Toronto, who've just been magical in their advocacy. And likewise, I want to extend a thanks to CAUT and David Robinson for their leadership. I want to just open just with a sort of just to take a temperature moment. I want to remind us that we're here, as much as there's a huge debate around, was academic freedom part of this position? Was she a staffer? Was she not? Whose academic freedom matters? I just want to remind us that, this was about a human rights clinic. And so no matter where you stand regarding the human resource issue, I just want to remind us that, whether you're in law or anthropology or STEM or political science, all of us are faced with daily discussions about human rights, those who have them and those who don't. I just want to take a moment to recognize we're here in Ontario a week after a Muslim family was literally run down by a white male simply because they were Muslim and looked different. And for those of us who've watched the Trump administration with joy end, we also saw that things like democracy are pretty fragile and require regular attentiveness, practices in the ordinary course of businesses, as my colleagues in Anthro might appreciate. And so I just want to be mindful that as we think about questions of academic freedom, these are really lofty ideas. But what I want to do is really address, how do we make them real? And in this particular context, we lost it. Here, what happened and what's been articulated is that a donor prompted by a third-party advocacy organization raised concerns about a candidate's competency. The Cromwell report makes that fairly clear. The Center for Israel and Jewish Affairs prompted David Spiro, an alum and donor and judge, to make inquiries, but about a candidate's qualifications and her competency to be director. But let's be clear about that. Assessing qualifications of candidates for a clinical position in an academic program is our job. It's not anyone else's. It's part of our mandate and not the business of a third party. And as much as the Israel-Palestine exception is part of this, and I want to thank Mohammed for that, I just want to remind us, it doesn't really matter if it was CEJA worried about a human rights director, or the Mining Association of Canada worried about the School for the Environment hiring an anti-mining activist, or a pharmaceutical company with major donations to the university worried that one of our faculty will find something in their research that will undermine their FDA approvals. In the case of Dr. Azarova, the opposition to her was about her research and her scholarship on Israel and Palestine. Now, years ago, I founded a journal on Middle East law and governance, and I knew this issue was always challenging. And we put in processes around editorial reviews to make sure that we controlled for those politics. We put them in place precisely to maximize academic freedom. And I've always thought, at least until now, the university is the one space where we can have that free and open conversation around Israel and Palestine, just as we did in the pages of that journal. Now, I no longer can believe that, or I can no longer assume that. Here at the institute that I run, I'm really grateful to have colleagues Jens Hansen and Alejandra Paz, who lead an initiative called Hearing Palestine. That project is central to that project is what does it mean to talk about Palestine, to center Palestine in the analysis of whether either the conflict there or the 19th century or the 18th century. And can we have a conversation that allows those voices to be part of a conversation, voices that are often silenced. But here's the problem, and here's the problem that the Cromwell report, even if you take the Cromwell report on its face, even putting aside the criticisms of his conclusions, if you take the Cromwell report on its face, we have to recognize that for me and my colleagues on Hearing Palestine, we now must risk assess for third-party interference with possible university complicity in Hearing Palestine. I have to assume, as a director of an institute, that any program that centers Palestinian voices will necessarily be subject to attack. So in addition to developing the kinds of academic vision statements that you and I oftentimes make in the course of a grant application, now we're having to deal with risk assessment mechanisms and risk assessment documents that have to do with third-party organizations and university supporters. Now, I have a great amount of respect for the Dean of the Faculty of Art and Sciences, and her support for me has been tremendous. But that is not the point. Risk assessment is now a reality, and we have to acknowledge that that is a reality from the Cromwell report. So now, I've used Hearing Palestine as a very specific example, but it's bigger than that. It's bigger than the law school. It's bigger than a program at any faculty. It's fundamentally about how we, whether you're York University or U of T or any other campus, how do we govern a university at a time when the university is increasingly turning to private philanthropy to support innovation? Now, I will be the first to tell you, I do advancement. I work with really actually quite spectacular advancement personnel. I've had a really positive experience working with them, and I'm really grateful to the donors that have come forward. But I will say, and it took me a while to figure this out as an academic who wasn't trained to do this, we really need to take seriously how we transparently govern in a context of private philanthropy, which precisely because it's private is by definition not transparent. In a context where public funding of education is subject to democratic mechanisms of review, transparency, and of course elections, there's a way to deal with that. But in private philanthropy, we don't. Donors have the ability and the right to give to U of T anonymously, and they can structure their gifts in certain ways. And of course, the limits of academic freedom do limit the scope of that structuring. And it's up to deans who take the lead in negotiating these agreements. They sit in a complex situation where they have to both manage the possibility of donor input, donor support, but also academic freedom. It's not an easy job. And I'm not suggesting that we should always be suspicious of every single dean. I'm not here challenging the quality of character of any particular office holder, but I want to recognize that as we as faculty look for greater clarity and transparency, we're not here criticizing the person of the dean or the president. but we separate the dean and the person together. If we don't, then we run the risk of in our criticisms being construed as engaging in a kind of medieval mode of lèse-majesté, a kind of offensive against the king's two bodies. Now, I invoke medieval kingship here deliberately. Part of it is it's a conversation we've had at the law faculty, but my colleagues Denise and Mohammed characterize the U of T that it operates like a corporation. But I want to invoke Ernst Kantorowicz because of my fear that in this case, and I'm not sure this is alone, I think it's across a lot of units, we saw a collapsing of the person and the office in the spirit of a kind of medieval theory of kingship where criticism of the person was a form of disloyalty and therefore precluded transparency, precluded the possibility of greater, more cohesive governance among colleagues. And as we further pushed and advocated on behalf of the IHRP in what we thought was a violation of academic freedom, what we found is that we don't seem to have in plenitude at the law faculty, at least, a regime of transparent collegial governance, especially when it comes to operating our core mission in light of private donors and philanthropy. This is not going to be unique to us. This is going to be your departments as well. None of us are naive here, nor should we be. Deans are going to get external pressure. They're out there pressing the flesh, and we're grateful for the work they do. It's thankless at times. But I'm mindful that we've so siloed advancement in collegial governance that we do, as I've said before, run the risk of confusing the dog for the tail. U of T is not alone in this. All of you are probably in part of universities that are like this. So there's a lot of questions of, well, what do you do to fix this? How do we think about the governance part of it in this context? For as long as the province of Ontario seeks to not fund higher education, private philanthropy will necessarily be a reality. So on the one hand, we need to have better trained advancement professionals, and President Gertler's office says that's what they're going to do. But I think there's a larger problem here, and we have to think about how we manage the university together. At the faculty of law, when I first came, I was struck by the utter divide between staff and faculty. Staff unionized, faculty not. Staff not enjoying academic freedom, faculty doing, most certainly enjoying academic freedom, though perhaps not as much now. In a context of philanthropy, when we rely on staff to do a lot of the paving of the pounding on the pavement, we need to rethink what governing collegially with staff includes. Staff have a stake in the university just as much as we do. And let's be frank, staff and faculty, we don't often get along very well. We don't often integrate very well. That's a problem that we need to resolve internally within universities. But we also need to think about incentive structures. When we think about fundraising, the focus tends to be on the quantum dollar amount. But if in fact philanthropy is being used to offset the diminished funding from the public sector, then don't we need to also integrate in advancement incentive structures, equity and diversity considerations? Do we always need to go after the big whale? The big whale might always be racialized in a certain way. What if we restructure advancement priorities and incentives to recognize that philanthropy needs to be equally representative and democratic? And of course, whistleblowing. If we're going to integrate staff and faculty in the mutual process of running a university, what kinds of protections do we need to give to staff? Vincent, who you heard speak, is a prime example. He had to resign his position before he could feel comfortable talking openly. The fact that people would have to resign to do that, we need to really think about whistleblowing within this context in order to preserve considerations around academic freedom in this particular setting. These are just a couple ideas I want to put out there. I haven't really formulated them robustly, but I do want to share them with you, and I want to thank you for your time this evening.
Tremendous. Thank you so much to all of the panelists, Denise, Mohammed, Vince, and Anver. Vince said at some point during the chat that there is a tremendous amount of fire going on, and I would just second that. So thank you so much for those interventions. So now we're going to turn to the question and answer period. We do have a full half an hour left for that purpose. So just to remind everyone, if you would like to ask a question, you can do that by typing it into the chat window. And if you're not comfortable, either doing that, or if you'd like to withhold your name and ask a question anonymously, you can message Emily Albert directly in the chat to do that. And so we'll launch right into the questions. I will sort of do it a little informally and ask the question first, and then leave it up to the panelists, as well as Malavika, of course, to intervene, basically whoever wants to go first with the questions. And then, of course, during this time, if there's an appetite for the panelists to comment on one another's presentations, that's also something that would certainly be welcome. So the first question that we have comes from Susan Froome. I hope I'm getting the pronunciation correct there. And Susan says, I'm a current undergrad student member of a governing council at U of T. I'll also be on the academic and university affairs boards in the coming year. Do the panelists think that this affair was the result of a lack of good university policy, or was it the result of good policy not being properly understood and applied, or both? What might good policy look like in this context? And again, whichever panelist would like to take the first shot, I invite you to jump in at this time.
I'd like to comment on this just because the president of the university has tried to throw advancement under the bus and say, oh, the problem here is we didn't really have good policies. We'll work on the policies and everything will be fixed. Sort of like, Denise alluded to that in her presentation. My point is that if you take academic freedom seriously, and that was the claim made by the dean and the president when this first broke out, we were so offended. How could you imagine something like this happen, right? This is so offensive. It's deeply insulting to even think that this could have happened. Well, then that just suggests that it's not a problem of policies, right? Because the violation was so obvious. Any sentient person would realize that you can't do this, to say nothing of people with the training in advancement and the assistant dean and faculty of law who all aided and abetted this, right? So to me, that signifies that there's some institutional defect in the University of Toronto with respect to relationships with donors. What's not clear to me, and this is honest, right? I'm not trying to, diss the university. What's not clear to me, is this across the board? Is this the way we treat all powerful donors? Or is it just limited to this one issue, right? I don't know which one is worse, to be honest, right? But I am convinced the only way to find out is to have a real investigation of Simcoe Hall and of advancement, right? To get to the bottom of the culture that allowed this to happen. And I'm convinced that we're never going to get that because there's no will in the university to investigate itself. It will only have to come from the people of Ontario, right? And I just don't think they pay attention to this, right? But I think there is a deep institutional problem here, and it's not clear how we can possibly solve it through policies because there's no will to uphold them, to maintain them in the face of meaningful pressure from powerful private interests.
So if I can just add briefly to Mohammed's point, the University of Toronto and maybe other universities are just as bad, although I kind of doubt it. University of Toronto talks a really good line about all kinds of things, and then it behaves very, very differently in reality. And it's not just about the way donors are treated or how much influence they have. It's about all kinds of things. I mean, within the faculty, it's kind of legendary hallway gossip how the word consultation is bandied about when it just means that somebody's going to say, I consulted widely, and then here's what I decided. So there is so we talk, we express certain values that we would all agree with as important. Collegiality, consultation, academic freedom, collegial governance, freedom of expression, and then the powers that be at the university just act, according to, I think, really quite different values. And I don't know how we come to, we come to grips with that and change it. I think it's really important to notice that in this instance, the dean spoke to the provost and the vice president of human relations before making a final decision, and mentioned to both of those senior officials in the university that there had been this intervention by a donor, but of course he wasn't really paying very much attention to it. And as far as anybody can tell, none of those people said, hey, wait a minute, let's just pause here and make sure that we are not rushing into a decision that we're going to regret because, we're in a hurry not to offend a donor. And that is amongst the most shocking things to me in this whole affair. So we have right principles, we don't know how to act on them.
Can I quickly, because I think it's thank you so much as a member of the governing council, a student member of governing council. So I'm going to make a micro comment and a macro comment, just like my presentation, right? So the formalistically, right, the university president, of course, is accountable to the governing council, and the way that universities are supposed to be governed, in the way they developed in the 60s and 70s in Ontario, are that the students' representation, alumni representation, faculty and staff representation was supposed to add some sort of accountability counterweight or a democratic counterweight to the growing power of like just unaccountable administrators. But it's really, really difficult in the time of kind of the neoliberal university, which has been increasingly divorced from public education in general, and the overarching idea of excellence, right? So excellence being kind of coded as raise as much money as possible for this university in this kind of arms race with other universities, subject to, throwing anything else under the bus. And so I do think you as an individual have a lot of power insofar as raising questions within governing council, just kind of following up on the accountability and transparency questions. So we obviously have breach of protocol left, right, and center that was, detailed an incredible amount in the call. So what is being done about it? Who is taking accountability for it? It's been 9 months. What has happened, right? So all of these questions can be brought up, I think, at the governing council, and it's extremely powerful, I think, for governing council to work with, Censor U of T on that, right? So I think that's actually useful. But more importantly, how do we, again, wrest control of these institutions back to some form of democratic accountability and governance? And that's the whole, I think, idea, the broader, the more radical idea of we are U of T, or we are, any sort of community campus. Like, imagine this idea of academic freedom, but it only applies to certain members of the community, and it doesn't, academic freedom is the entire community, right? And every single one of the unions will have that in their collective bargaining agreement, but who kind of sets the tone, right? And so I think, students, faculty, faculty and staff, of course, Amber was talking about that relationship, but it is a catalyst, a way to think about who is the university? Who does it belong to? Is it really a couple of unaccountable, largely fundraising folks that are tied to, powerful political and economic elites, or is it something else? And I think that's the question that we need to think about. And if it's something else, then we have to organize for that. So that was my thought on it.
Great, thanks everyone. Okay, so I have one anonymous question. And so this person asks, what are some ways supportive practicing lawyers, including those on Bay Street, can be helpful in keeping the issue alive? What would be helpful from the panelists' perspective?
If I could take a stab at that, one of the things I think that's been already incredibly helpful is just the sheer social media support. I mean, if you look at the Censure U Toronto webpage, the social media platforms there. We've got some amazing alum as well involved on social media tweeting about these things. It's important to continue keeping the issue alive. There's obviously changes in our society, things are happening left and right, but trying to keep this issue alive and the conversation around the problems alive is essential. And of course, if they're alum of the Faculty of Law, certainly not only just do so on social media, but I would hope you would write to the dean's office. I hope you would let them know that you're watching, that you're concerned.
If I could say something too on this, I think lawyers have a special duty to maintain the integrity of the institutions in which they work. That's just kind of my background as a lawyer. I think that the Code of Professional Ethics imposes on us heightened duties. I think as a faculty of law, actually the statute, that creates the law society, et cetera, and that certifies us, recognizes the function of law schools as kind of guardians for the democratic institutions of the province. And generally speaking, lawyers are very privileged, and with great privilege comes great responsibility. And it shouldn't be all about making money. I'm not against making money, but that doesn't come at the expense of living up to your ethical duties to the profession. And that at times requires you to do things that are unpopular, right? You can't be the lawyer of an organization if you're not willing to say no to people who are making decisions, because that's really what your job is. Your job is to make sure the organization is following the law, and that means sometimes you have to be unpopular, right? And if you can't do that, then you shouldn't be a lawyer.
I think of it in terms of those who have, a business, like if they're Bay Street folks, like goes for the questions of what is economy, right? Like economy is always tied to politics. Politics is always tied to, it's like not what dogma says, but if there is a concerted effort to say that, hey, we're not going to continue donating to U of T law, or whatever, until we get, these sort of substantial changes that we need to have trust in our universities and academic freedom, and with respect to human rights, specifically Palestinian human rights, then I imagine that U of T is going to hear that message loud and clear. But that's just kind of my thought on it. Of course, it doesn't change the outlying role of capital in kind of ruling all of our institutions in our lives. But I imagine as a short-term strategy, that might be really powerful.
Here's what I would like to see lawyers do. I'm always struck by the fact that much of what students implicitly learn at the law school about ethics and collegiality and respect for dissenting views, etc., is completely antithetical to what will be required of people in the profession. So I think we're giving them a bad education at the law school, not overtly, but implicitly. And I would love for people who've been to U of T and then had some experience of the practice of law in which they were actually required to behave ethically and respectfully of one another, to say back to people at the law school, hey, you didn't actually do a very good job teaching us the things we need to know. And so maybe you actually should clean up your act before you send the next generation of lawyers out into the world. And I have one final bit of advice for practicing lawyers. Don't tell the current dean I said this. But if you were thinking of teaching a course as an adjunct at the faculty and you decided not to, I think that would get their attention.
Thanks. So this next question is related, but also quite different. So it's from the chat. Lena Lashin asks, where she says, I think a lot of students are afraid of what engaging in this movement might do to their careers and hiring prospects. How can we make them feel more comfortable and confident in engaging?
Can I try something here, Heidi? I've lived my life in a pretty non-strategic way. I grew up in the American South. I've always spoken my mind about Palestine. I probably have a laundry list of things that disqualify me from public office. I have no doubt about that. And I think one of the things that I jokingly say, I can do this because I have no ambition. And I think you have to live your life with without ambition, other than answering to yourself. Can you go to bed with yourself every night? And I promise you, a lot of the fear is self-imposed. It's a lot of bluster, because when more and more people speak out against us, against these things, they can't fire everybody. They can't keep everybody from getting a job, right? I mean, you are valuable people. The economy needs you. The universities need you. The future needs you, right? Don't let yourself be intimidated, right? So that's the only thing I can tell you. It's faith, right? It's not a guarantee. I can't enforce it. You can't sue me if it works, if something bad happens. All I can tell you is you have to have faith in yourself and your comrades and people and decency of people. But cowardice, the outcome of cowardice is known with certainty. The outcome of bravery is always open, right? And so when everybody acts according to their best lights, then change is possible.
And the other thing that one might say there is that the worst of all possible worlds is you silence yourself and you still don't get the job that you wanted or whatever. And then what, you were not true to yourself and you didn't make the advance in your career that you wanted. Way better to take a chance on being yourself and having faith, as Muhammad says, that you'll land on your feet somehow.
Hi, Denise.
Yes.
This is Bill. This is Professor Bill Graham. I'm
an icon is what you are. You're an icon.
Well, I'm in my 87th year. I retired in the year 2000. I was for 8 straight years president of UTFA, the Faculty Association, and then following that, president of OCUFA, the provincial, and then I spent some time as president of the CAUT. And I wanted to remind my fellow friends in UTFA that we've had 3 UTFA members who have been presidents of CAUT and have supported CAUT to the hilt. I was very disappointed to hear that UTFA had only abstained and was apparently had to be coaxed a bit in that direction by some other members of UTFA and CAUT. I think it's very important for our faculty association to stand fully behind our national body, the CAUT. And as I say, we've had 3 presidents from CAUT who are members of UTFA, and it's been our duty and our responsibility to stand up for academic freedom. I fought the battle for Dr. Nancy Olivieri before I retired. It took a number of years, and we had people in the association who were also opposed to that. But you can't say, and I know who some of the people are in the current UTFA area who are not in favor of the Faculty Association and not in favor of CAUT, but you can't simply go by that. You have to know what is the right thing to do at the right time. And right now is the right time for UTFA to take up the battle and fully support this and work toward the university changing its direction in regard to Professor Azarova. Thank you very much.
So I'm not sure if that was a question, Bill, but I agree with you. And I think think UTFA does have our back now, and it's full speed ahead.
Great, thanks for that. Okay, so another question, this time from Josh Seeley Harrington. And Josh asks, I'd like to hear from the panelists about their views on what forms of escalation should be pursued by U of T censure supporters if the university persists in denying a position to Azarova, and in particular, if the position is offered to another academic. And Emily has a follow-up to that question, asking, even if they hire Azarova, what else do censure supporters need to continue to push for?
So maybe I can start and then see if other people have something to jump in with. So the decision to censure the University of Toronto is CAUT's. And so CAUT is kind of in the driver's seat. Within the university, those of us who think that an issue needed to be made about this are eternally indebted to CAUT for making it possible for us to keep fighting. I think they're 100% committed to the larger issues here, but they can only do so much. And the rest of us in the university have to be prepared, have to think about what kind of reforms from the large to the small that we'd like to see in-house that would actually make the place more workable, more respectful, more collegial, just a better learning and working environment. And that's a really big job. It's a really big job. So I think CAUT is not going to give up as long as the University of Toronto does not offer the job to Valentina Azarova. The law faculty has made a tiny little step in the right direction recently, and we're waiting with bated breath to see whether that's gonna bear fruit. But apart from the question of Azarova's appointment, there's a lot of stuff that we have to do, starting with at the Faculty of Law, to make sure if she is offered a job and she does accept the job, that there's actually a welcoming environment for her within the law faculty, and that's no small task, But we just take every day as we can and do the best we can with it. I wish there were a master plan that was actually going to produce justice once and for all, but there isn't. We just take each day as it comes.
Denise, thanks for your comments. Let me just a couple of other thoughts here. I think people should be prepared for the possibility, two possibilities. One, that they magically find a minimally qualified Canadian to fill the role. That's what the cynics among us think is going to be happening over the next couple of weeks. But even assuming that does not take place, I worry about a major public backlash organized by the people who were opposed to her appointment in the first place. So this battle is not going to disappear, unfortunately. Secondly, even if it's hard to imagine that Dr. Azarova gets the job and there's no big public outcry and she gets to Toronto and starts doing her job professionally, we as a faculty and we as a university have serious problems of collegial governance. That was also one of the elements in the CAUT censure. Even Justice Cromwell noted that the former dean did not observe expected standards of collegiality. And what ultimately made this into the scandal that it has become was the completely despotic way of decision-making inside the faculty and inside the university. And you just don't know what other kinds of scandals are there. As Denise said, we only knew about this sort of fortuitously, right? And as long as we are sort of governed despotically, then there are all sorts of, what's hidden could be worse or is much likely worse. And so we need to work toward a much more transparent system of governance in the university for the benefit of everybody. It's also beneficial for the administrators because when they are accountable to faculty, they're in a much better position to resist this kind of corruption. and that should be stressed over and over again.
If I could just add two things, just because I think if I'm correct, the questioner is going to be soon starting as a faculty at Ryerson, and three things come to mind. One is constantly reminding ourselves that collegial governance is a sine qua non of academic freedom. And so really thinking hard. And so I want to reiterate Mohammed's point. We do not have clear faculty governance guidelines at the Faculty of Law. There's no constitution. There's no overarching document. My colleague David Schneiderman and I are working on this piece on the history of governance at the Faculty of Law, and we can't find much by way of meaningful governance documents. So that's problem number one. But problem number two is the Palestine exception is one among the many exceptions that we see across universities in what we study and what we articulate. We might want to call it, there's a canon, there's a colonial sensibility around the curriculum. You can use whatever term you want, but the point is what, and I want to thank the Department of History at U of T for this, is really putting front and center the fact that we need to do better to think about the way our institutions normalize the exceptions to academic freedom that we've otherwise normalized. So, Palestine is one that I'm working on, but there's others. And so if we can keep pushing on these sorts of issues, we can also hopefully push back against the imperatives that make these exceptionalisms possible in the first place.
So I think, as not being a U of T person anymore, like an external, I can just come out and say this, like, I think that's true. Like, somebody got to lose their job, and I think it's Gertler. Like, I don't understand how you can go 9 months on this thing. Like, okay, listen, this is okay. There's a bunch of private money, yeah, but this is still a public institution. You are responsible to, I hate to say it, taxpayers or whatever, right? But that's true, right? You have failed in like every single possible way to deal with this. Listen. The CAUT censure, this is like the first censure of its kind at a major Canadian university for 40-something years. There's much CAUT historians, tell me if that's right or wrong, but that's like a huge deal, and it's become like a global issue. How can you do this much damage? Yeah? How can you do this much damage to your institution that you are supposed to be leading? And you get paid an absurd amount, and there's no accountability, right? You get fired for like anything, but you can't get fired for this, right? So I don't know. Like, of course, that's not going to solve all the reform stuff, but it means something if somebody in power, has to actually take accountability and be disciplined for that. It means something.
Vincent, I agree 100%. I think the level of wrongdoing documented in the Cromwell report is so stunning that I was shocked the president, didn't resign immediately. I mean, somebody has to take responsibility for that institutional corruption, because that's the only way you can describe it. Sadly, I just feel that, our political culture is extremely tolerant. That's all I can say. It's shockingly tolerant. That's all, it's frustratingly so, right? But it's unbelievable that neither the former dean nor the president is willing to take responsibility for the actions of their subordinates that they claim was unauthorized and offensive and mistakes. Well, somebody has to take responsibility for it, but apparently University of Toronto, responsibility is not on the agenda for our decision makers.
Okay, so we are coming up to time, but I do see that Teresa Zorich, I hope I got that right, did want to offer a little clarification about the situation at UTFA. So I will give you that opportunity to do that, and then we'll turn the floor over to Malavika for some concluding remarks. But go ahead, Teresa, if you're still with us and wanting to add some flavor there.
Sure, Heidi. Teresa Zorich, and no worries. Very, very quickly, many thanks to the organizers of this wonderful event, Censure U of T, and all the activists who've made it possible for those of us doing institutional work to have some room to maneuver. I wanted to offer that as an early leader who defended the folks at the law school and the principles of academic freedom and collegial governance, there was nothing short of unending harassment and psychological warfare, where those of us who are supportive of the principles at stake at the heart of the censure experienced horrible backlash by an entitled, powerful Zionist minority that felt that any criticisms of Cromwell or anyone else could be met with accusations of anti-Semitism. And it took an enormous amount of work to get us to a point where we could even have a conversation about what went on, why it went on, and so on. Many graduate students with whom I've worked, I teach in the Department of Social Justice Education, have complained that anytime they want to talk about boycott, divestment, Palestine, or anything like that, they feel targeted in similar ways. If you don't think faculty themselves, including those of us in senior positions, can be intimidated by the powerful response, you don't understand what's at stake. And we continue to be in that position. So Bill, I think you are a fantastic model of an UTFA president who continues. We need ongoing engagement with and at UTFA. We need you to ask yourselves, if you're UTFA members, who your constituency reps are supporting, whether or not they're stepping forward. I know we're at the end of the event. The connection between institutions like UTFA and activists who are able to push UTFA is crucial here, in the same way that UTFA is crucial to push the administration. I'll say I've written a letter to Gertler asking for a public event in which he answers people's questions in an interactive dialogue. And what do you want to bet that won't occur? What do you want to bet that the moment of truth won't come where he has to answer people's questions? So I've taken what I hope has been a principled, educative, slow and clear direction, that the most powerful thing we have on our side is the truth about what occurred, and a conversation that requires people to answer respectful questions in a way that's not just about a bunch of slogans. And I don't think they can win an argument that is done slowly and clearly, because the facts simply aren't on their side. So I'm going to say the majority of those of us who are at UTFA are supportive. The question becomes whether or not we're going to have support on the outside to keep us moving in the correct direction. And William, I'll be reaching out to you to help me organize some of the retirees, because some of the most active people in the backlash are retirees who are trying to speak on behalf of UTFA's retirees. And you don't get what you deserve, you get what you organize. So thanks very much to the organizers of this event.
Thank you so much. So very quickly, I just want to say a huge thanks to everybody for coming. The level of engagement and participation is just really, really heartening on this incredibly important topic. And it was my pleasure personally, and also the great pleasure of Osgood and the Nathanson Center to be able to host this event. And of course, thank you to all of the organizers and speakers. And we will keep folks updated on the next iteration of the teach-in series. But I won't close the event. I will hand it over to my co-moderator, Malavika Kastori, to say a few final words before we end. But thank you, everyone.
Thank you. Thank you, Heidi, and thank you, everybody. I'm sorry we're running out of time because these questions and also the discussion that was generated actually suggest to me that we need to be taking these up in the teach-ins that we are hoping to have. We will be updating you on Censor U Toronto, and I think the next event will carry forward these very, very crucial issues, which actually are about the law school, but they're also about all disciplines. They're about the university. And, you know, as a South Asianist who's also where, you know, there has been also a very dirty history of an ongoing history of philanthropy and donation that silences work on Kashmir. That also now is silencing work that does not speak, that critiques Hindu nationalism. I would like us to also connect and perhaps think how we can connect this really important discussion on Palestinian exceptionalism to those in other parts of the world, where ironically, even in public institutions, which are here, which we have spoken about in many ways, as sort of a way out of the bind of private philanthropy, very often those public institutions often become the site of oppression if the state is oppressive. So these issues and more will be part of our ongoing conversations. We obviously are focused on the law school, but we want to also broaden the discussion to sort of also to actually reiterate what I said at the beginning, that everybody who's interested in the university, from whichever sphere you sort of have come to this discussion, please talk about it. One way of actually engaging with it is actually having media programs on it, on television, in the print, and also in class to teach it, when one talks about academic freedom. But so on that note, I wish to thank everybody who participated, a great panel, all my colleagues, and my friends, and of course the wonderful audience. We look forward to seeing you in the second of the teach-ins, and so please watch all our socials, as my daughter says, that the social media handles, and Censor U of T Toronto for details. And I'd like to also end the evening by thanking Heidi Matthews and all this wonderful group at Osgood Hall for hosting this event. It would not have been possible without you. And so thank you all, and thank you to the panelists for doing such a great job. Bye-bye and good night. Thank you so much.